They will, of course, look at how you're dressed. Normally, a week before the oral, you normally have a presentation, and then you'll be addressed by Miss Konuche and some other lecturers. So basically, they will guide you on the colors allowed for ladies. For ladies, you can do a skirt suit, trouser suit, or a dress suit. For men, yes. And then kindly, KJ, just mute, tafadhali. So basically, you just make sure that you present your content well, and again, make sure that you're composed and you're audible. For things that may not get you marks, I remember last year when we were doing our orals, there's a lady who came with all, I don't know what had happened to her. So she had all colors on her nails. She didn't have one uniform color. She had all colors on her nails, and the nails were very long, and she just looked funny. So the panelists were not very happy, and I think she was given a 3. So for ladies, you can do your nails, but just make sure at least you have one color. Outside there, you can do your nails vile unataka. But for that specific day, please be very, very neat. If anything, you might not have content, but if you're very well, you present yourself very well, I think that should do it for you. So just avoid funny things like mini skirts, very revealing tops, and you'll be guided. And the colors of the nails, unajua hiyo hakuna mtu atakwambia usifanye. But this, again, remember, you can dispute these marks, but the examiners have the last say. So I think it's just good to not piss off the examiners, because utasema I have my rights, my nails, I will do them how I want to. But you see, once the examiner decides the mark they are going to give you, that's the final mark. In fact, hata mtaambiwa, that's the final mark for you. So just make sure you don't do anything that can deny you marks. So basically that's it. But you'll have a meeting with Miss Konuche and some other lecturers who will guide you better. We had such a session, so I'm sure they'll do it for you guys. So not to worry, it will be handled before the oral. Is your question answered?
Yes, thank you so much.
Njeru Alice, what's your question?
Hi, Nyambura.
Hi.
So I'm asking, have you come across any legal consultancy, and what do they really do? And what is the difference between what is done in a legal consultancy and a law firm? And again, is it a must that legal consultants have to be advocates? And finally, still on legal consultancy, do they have a regulating authority or body like LSK maybe? Thank you.
Okay, Angelo, do you want to answer that question in a minute?
Thank you, Nyambura. I think, Daniel, you could be in a better position to answer that question.
It's okay. Yeah. The question has been asked by Alice, I want to believe. Yes. So, Alice, of course, there's a difference between a legal consultancy and a law firm. If they were the same, then I think everyone would go with a legal consultancy. Now, the difference is this. In a law firm, you'll find partners who are leading it, and these partners and associates who are there are advocates. There's a difference between an advocate and a lawyer. And I hope, again, this is something that, again, you guys have learned in professional what? Yes, I'm sure that you guys have learned that. And professional ethics, sorry. So a lawyer is someone who has a law degree. Okay, but a lawyer can be an advocate. I mean, depending on whatever you want to use. But an advocate is someone who has passed their bar exams and have signed the role of advocates. So in a law firm, you'll have advocates. Of course, there are pupils and the rest who are looking towards being advocates. But in a law firm, you have advocates. In a consultancy firm, you have lawyers. Meaning, these guys, it could be that these guys have not been admitted. Yes, you can hear me. Someone is speaking. Okay. So in a consultancy, you'll find lawyers, people with law degrees, but they haven't done KSL exams or the bar exams, and they're not advocates yet. Now, this doesn't mean that in all consultancy you'll find lawyers, but consultancies are led by lawyers. Firms are led by advocates. A lawyer is someone who has a law degree. Probably they've done, they've gone to the university, they've passed, they have a law degree, but they have not been admitted into the role of advocate. In a firm, you'll find advocates. Advocates are those who have passed their bar exams and they have signed the role of advocates. Okay? So then there's a difference there. Now, in a law firm, of course, a lawyer, like you right now, you have information about law. There are things that you know about contracts. There are things about tort that you know. There are things about divorce that you know. There are things about. So in a consultancy, and the reason why it's called consultancy is you'll consult them and they'll give you the opinions in relation to legal matters. They'll tell you this is the problem, this is the solution, this is what the law says. This is the issue. This is how you should do it. This is what the law says. You want to employ people. This is how the contract should look like because this is what the law says. But when it comes to the extent of representing you in court, they cannot represent you in court. Why? Because they are not advocates. Probably they'll refer you to someone else to represent you in court because they don't have the locus to represent you in court. But in a firm, you'll find advocates who will not only give you their opinion, but they can also draft pleadings and they can draft legal documents and stamp them and represent you in court. So that's the difference between a legal consultancy and a law firm. Is that okay? And is that clear, Alice? Do you have any further questions?
Yes, that is clear. My follow-up was, what is the regulating body that governs legal consultancies?
Thank you. Now we have the disciplinary committee or commission, depending on how you want to call them. Then we also have the LSK. The LSK and the disciplinary committee only regulate advocates. Now, this is something that we talked about when we had, I think even you guys at some point, you'll have, how do we call it, a training from the disciplinary committee or a debate or whatever. They'll come and share with you a few snippets here and there. So what they said is the LSK and the disciplinary committee only regulate advocates, people who have signed the role of advocates. But when it comes to lawyers, honestly, they don't have regulators right now. But look, this is what I think. If you have an issue with a lawyer, someone who is claiming to be a lawyer, then there's always professional negligence. If at all they've given you a solution that did not work because they misguided you, then you can go to court under tort or under professional negligence and get back that which you have lost. But when it comes to issues of ethics, these guys are lawyers. These guys are not advocates. So you cannot take them before the disciplinary committee or commission, and you cannot take them before the LSKY. These bodies regulate advocates. So when it comes to regulation, probably the only solution that you have, or the only remedy that you have, is where you have an issue of professional negligence. Then you can take these people to court. Why? They are professional. I mean, they have learned about law. They guided you. They were in that, but for their information, but for their advice, you couldn't have done what you did. So, of course, the courts are always there, and you can sue them under tort. But when it comes to issues, ethics, and other things, I'm sorry, but I don't think you can take them anywhere. Yes, Alice?
Yes, that is clear. And now finally, if then that is the stand, can they then give money back guarantee for their services?
What do you mean money back guarantees?
Yeah, I promise to do something and I promise you a certain result. And if the result is not what I promised, then I'll give you the money you paid me back.
Of course, why not? Freedom of contract. Have a contract with them that says that if they refuse to take them to court. So yes, that can happen.
Okay, thank you. Thank you so much.
Thank you. Yeah. So that gap is there when it comes to regulation, and I think we even talked with the disciplinary committee around it. I mean, these guys can do anything. I mean, there's a problem there. So maybe in the future we're going to have regulators who are regulating consultancy firms, or I mean, who knows? Maybe at least one day when you become a big shot in this country, maybe that will happen. But thank you. That's a very good question. Nyambura, back to you.
Let's have Evelyn Evans Miruri, your question, then we move to mock oral. Mwangi Evans, your question.
Okay, thank you, Nyambura. My question is, when you approach the panel during the oral examination, how will one be introducing themselves? Like, will one be stating their religion or something like that?
Let me just answer you.
The introduction.
Let me just answer your question real quick.
Yes.
Normally avoid your religion or where you come from. I'd advise you introduce yourself in relation to KSL. So maybe you could say, my name is Evans Mwangi. My registration is number is 2023, blah, blah, blah. Then I am from class G. I am a member of whatever. So anything that relates you or connects you to KSL, then that is what you use as introduction. So for, let's say, saying you're a Christian, saying you're from Kiambu, I'd say avoid that. Because again, as I said, yes, panelists are supposed to be neutral, just like how judges are supposed to be neutral. But these people are humans. You could say you are from, let's say, Uasin Gishu, ama let's say you could say you are from Kiambu County, and probably the panelist doesn't like people from Kiambu for whatever reason. I'm using Kiambu because I'm from Kiambu. So you could say you're from Kiambu and the panelist for some reason is pissed. So just use the information that is related to KSL. That should suffice. That should be enough. Is your question answered, Evans?
Yes, it is answered. And when we speak, it does elapse, but it will come back. When it comes back, I'll ask you the question.
Yeah, sawa. So that's it. We will now start our mocks. So Daniel will go first. Then we will have Angelo. We have more panelists today. So in the meantime, let's just say it's we have Daniel, we have Angelo, and then we have Mwasia. Tunamwitanga Etihad. In fact, today is his first session. I think he will go first. So we'll have Etihad, then Daniel, then we'll have Angelo. So can we please have a first volunteer? Each session will take 10 minutes. So when you're asked a question, if you can, please answer the question directly. Because normally at orals at KSL, you normally have 10-15 minutes max. So anybody, any volunteer? So we have Etihad starting us off. Etihad, are you present? Kindly signal me if you are.
Hello, Ms. Gishuhi. Can you hear me?
Yes. Yes, I can. So let's get a volunteer for you, and then you'll start us off.
Around. Sawa.
Sawa. Lual John, you're ready to start?
Yes.
Sawa. Mwasia, pick it up.
Ms. Gishuhi, how many minutes do we have with Mr. Lugaho?
You have 10-15 marks.
Sorry?
I'm saying you have 10 minutes, 15 minutes maximum.
Okay, sorry. Thank you.
Yeah.
Mr. Lugaho, Good. Let me assume that it's an afternoon that you are appearing before the panel. So good afternoon, Mr. Lungaho.
Yes, good afternoon.
Just kindly introduce yourself.
Thank you. My name is Lual Garang, Class D, Form 9. And my registration number is 2023-15-14. And I'm ready to proceed with my oral exams. Thank you.
Okay, karibu, Mr. Garang. Are you a Kenyan?
No, not really, but I've been in Kenya, so I'm a Kenyan by living.
You're Kenyan by?
Living.
By living. Okay. So I assume you want to be a Kenyan citizen. Can you name for me 2 ways through which you can acquire Kenyan citizenship?
Okay, thank you for asking me these questions. I can acquire Kenyan citizenship through registration, and this one I'll be doing it through the county, which I'm interested to be a member of that county. I'll just apply and submit my application, and to wait if it is going to be accepted, then I will follow the next procedures. Number 2, I will just acquire Kenyan citizenship maybe through by the simple way. Maybe if I marry a Kenyan lady, because I'm a man, then automatically maybe I will be a Kenyan citizen. Thank you.
Okay, thank you, Mr. Garang. So in class G, who is teaching you commercial transactions?
I'm from class D. So the one who teaches us commercial transaction is Mr. Fred Kimwani.
Fred?
It's Mr. Fred. Yeah.
Fred Kimani.
Yeah.
So have you covered the MPSRA? Movable property security.
Yes, we
so
covered.
Can you,
although we have not finished it,
Mr. But
yes,
you have started though.
Yeah, we have started. Yes, yes.
So can you name for me 2 types of notices recognized under the MPSRA?
2 notices under MPSRA. One notice is I think we have not reached that far, but we are just on the part of introduction. Kindly fast.
Okay, fair enough. So what will you say is a movable property?
The movable property.
Yes.
Kindly repeat the question.
Mr. Garang,
yes.
What did you say? Or how would you define a movable property?
Okay, thank you for this question. The movable property refer to the property that can be transferred from one place to another. Assume like the good example is like the money. You can transfer your money from the banks, no matter where it is, you can transfer to where you want. Also, the like when you have something like vehicle or whatever that can be transferred and it's not something to relate with land or the property like houses or anything that can be transferred is referred to the movable property.
Okay, thank you, Mr. Grang. I want to assume that you started your trial advocacy classes. So,
Yes.
assuming that you are an advocate, and you have a client who has approached you to represent her in a theft case, and you want to, he is accused of stealing some goods, and now he is on the dock. Your client had stolen some stuff. He's disclosed that to you, and being his advocate, you have the task to do a cross-exam on that client. Can you ask me 3 questions and the examination in chief that you will ask? Just, and don't dwell on the introductory questions.
Okay, thank you for this. Since you limit me not to go for introduction first, I will just ask where I will just supposed to ask first where were you when this incident happened, and what is the which place were you, and who what kind of property have you accused to be in possession that you have stolen?
Thank you, Mr. Grang. Well tackled. Well tackled. Thank you so much. Now, on my very last questions, I think I'll ask you 2 more questions. I would like to delve into the issue of wills. Have you covered the wills under the probate?
Yes.
So what's a will? What will you say is a will?
Okay, thank you for this question. A will is an interest that a person can, or a person wish to transfer or to surrender to another person in terms of wish that can pass after death, or it might not be, or it might be that it will be first to a person that the one who want to make that will to probate. So, like if I want to give something to a person that I want, that is what you consider to be a will. That it is just a wish that you want to give to a person.
Okay, thank you, Mr. Grang. Must the will be in writing, or we can have an oral will?
Yes, and thank you. In section 9 of the subsection, we have oral wills, which can also take place when we under section 11. We have written will. So, in order for the oral will to be considered and to succeed, there must be 2 competent witnesses, which are not beneficiaries. So, and the written will, it is also must to have the 2 competent witnesses who are not beneficiaries. So, meaning that even if the will is made orally, it must be in writing. So, in order to probate, so the will should be in writing, but there is no penalty or making an oral will. as long that it includes the two competent witnesses.
And what do you understand by a privileged will?
Okay, thank you. Privileged will is the will that is made by a person who is under who is in a who is doing services, who is under some services like when you are on duty, like if you are a KDF, you are in a front line, so you can make a privileged will because you might not know whether you are not going to survive in that circumstances, so you can make a privileged will.
Why would we say that it's privileged?
Yes, it is privileged because you cannot you may not know what will happen to you, so you just tell to somebody who is just with you during that time to go and tell or go to explain that you make it. It is privileged because that you make it to you predict maybe your life might not be, or your life is in danger for that reason, so you can make that privileged will in order to be passed by other person when you might not be survive in that situation. That's why it is called privilege.
Thank you, Mr. Garang. Thank you for the responses to my questions. Back to you, Ms. Gishuhi.
Thank you very much.
Do we proceed to the second panelist?
Yes,
for Mr. Garang?
Yes, just give your feedback, Moasia. We are having one panelist for one student.
Oh, okay. Thank you. So, Mr. Garang, I really like the confidence that you've exuded in the responses that you've given. You have an idea basically on all the questions that I have posed to you, and your responses are very well grounded. Now, except I've got a few issues with some of the answers. And first of all, with respect to citizenship, on the allocation and distribution, the schedule of distribution of roles between the central and county governments, the registration of persons still a function of the national government, and therefore I do not think that you'll be seeking citizenship at the county. That's still a function of the central government. Now, with respect to the MPSRA, I like the honesty that you've given. If you appear on a panel or before a panel and they ask you a question on an issue or on a topic that you have not yet covered, it's good to bring that to their attention so that they'll limit themselves or they'll restrict themselves to questions in the areas that you've tackled, because it will do you more harm keeping quiet and being asked questions that you will be clueless by the reason that's not yet covered in class, than being proactive and confident enough to tell them, yeah, we've not yet reached that point. So the two types of notices, you can say we have the initial notice, we have the cancellation notice, we have the amendment notice. That's contained under the Act. So if you've not yet covered that, then you can have a look at it. Now, on the issue of wills are expression of intention or their expression of the wishes of the maker or a testator as to how he like his properties distributed upon his demise. So it's not a must that a will be in writing. A will can be either oral or written. There is no formalities to a will. And privileged will, on the issue of privileged will, remember that for an oral will, for it to be valid, then it must be made before two competent witnesses, and the maker of the will has to die within 3 months, if I'm not wrong. Yeah, should be 3 months after he made the will. Now, for privileged will, they are called privileged because they do not have to meet the strict formalities of oral wills, in that it's not a must that the maker of the will dies within the 3 months. In as long as he's in active service, even if he dies in the 4th month, if it was not privileged, then that oral will would fail. But since it's a privileged will and it's made either by a merchant marine or an individual in the armed forces in an active service, if he dies within that the description of an active service, then even if the time frame passes the 3 months provided for oral wills, then that will still be valid. Then with respect to the questions on the examination in chief, I wanted to test on whether you appreciate the 5W, the 5W and H type of questions or approach to questions in examination in examination in chief, and you really nailed it. You really performed well for me. So yeah, that's my feedback, Mr. Garang. Well done. That's a nice try. Back
Thank
to
you. Thank you
Ms.
very
Gishu.
Thank you, Mwasia. Let's get another volunteer. This time you will have 2 panelists because the panelists wamekuwa wengi. So you'll have Daniel and Angelo. Kindly let's get another volunteer, guys. We have Lim Thomas. You ready to go?
Yes, I am. Thank you.
All right, Lim. So you'll have Daniel and Angelo, 10 minutes. So it's going to be 5 minutes each. And ladies, muache kuniangusha. I want volunteers. So Daniel and Angelo, take it off.
Thank you. Lim, just before we start, just maybe a general comment to Garang. Garang, I think you're doing well. From the last time to today, I think you've really done better. All the best. Keep pushing, man. Keep pushing. You can do this. Now, try to avoid words like maybe, I think. It means you don't know the answer. So just give the answer. Give the answer. Stop using the words like maybe and I think. They might seem safe to you, but they mean that you don't know the answer. You're not sure about the answer. So try to be direct. Don't use the blankets. Just, put yourself out there. Okay. Lim, how are you?
Fine, thank you, Daniel.
All right. Kindly introduce yourself, sir.
Yeah, good morning or evening. My name is Thomas Elim Lim. Registration number 2023-1228, class G, in this school, that's Kenya School of Law.
All right, Lim. So I have a few questions for you. Okay, and this will be quick. So I'm an advocate. I'm working together with an estate agent. His firm is called Mapis Investments, Kenya Limited. And we've had an agreement with this estate agent He calls himself an estate agent. I'm supposed to give him 10% commission because he's the one who has referred to me a client. I'm a conveyancing lawyer. And this deal has gone through, and the property has actually been sold to this client who was referred to me by this guy from Mapis Investments Limited. However, when it comes to the time of payment, I realized that this guy called Edwin is not registered. He's not a registered estate agent. What are my options in that circumstance? Let's say I've come to your chambers and I'm looking for answers. What are my options?
Yeah, okay. Thank you for that. Now, first and foremost, an estate agent has to be registered as per the law. There is, I can't remember the act, but I will check. I don't know that it's
the Estate Agent Act. The Estate Agent Act. Yeah, go ahead.
Yeah, he has to be registered. Now, in this case, what you have, okay, the first thing that has to run into your mind is that the transaction that has happened, that transaction is valid. The transaction has happened. However, the agents, by virtue of being not registered, then you are not entitled to kind of, there is no prescribed where you can handle him, at least to my knowledge. And in the case of Mapis Investment versus Kenya, I think Kenya Railways Corporation, where situations like that were manifested in the circumstances of that case, the agent after selling the land, the principal paid him less than what was agreed, and he used that argument in court when the agent sued him. He sued the principal. He used that argument in court, and the court fined him, fined in his favor, and the agent was just, I mean, it was more like a favor that he was paid. So in this case, you don't have any responsibility towards the agent. That's what I'm trying to say. You don't have any responsibility towards the agent, but the transaction will stand.
All right. So I can decide not to pay him or her, right?
Yes, because by virtue of being not registered, you are not bound to do that.
All right. What if this agent was, what if this client was referred to me by an advocate acting as an estate agent?
If the client was referred to you by an advocate?
Yes, who is acting as an estate agent?
You mean the advocate? The advocate is acting as an agent. That is, yes.
Apparent.
Okay. Now, in case of the advocate, what should run in our mind is Section 34 of the Advocates Act, the question of qualified persons, and the case of the National Bank versus Anaj warehousing comes into play here. So in this case, if an advocate was registered and he referred this person to you, so the agency part here applies on the advocate, then you will now ask yourself, is he registered or is she registered? If she is not registered, again, the transaction will stand, but the advocate will be liable, because for the purposes of the issue in Anaj housing case, or the National Bank versus Anaj warehousing case, was was that the advocate didn't have a practicing certificate. By that virtue of having no practicing certificate, and I assume in this case, if he's not registered, it's on the basis of that certificate, then he will be liable as an advocate, as an individual, and that can, the mechanism for holding him liable, like the disciplinary committee of LSK, will come in. But the question of transaction, again, will still stand as valid.
All right, Lim. I'm asking, this advocate is acting as an estate agent, not as an advocate.
Yes. Yeah.
Yes. Will I still pay him, or it will be the same thing? They are registered.
You will pay the advocate if he's registered. If he is not registered, again, the same case will apply.
All right. The advocate wants me to pay him as per the remuneration order.
Now, if he's registered, you can do that. If he is registered.
All right. All right.
You can do that. If he is not registered, the law has not placed any duty on you towards that advocate who is not registered. The only duty that you have is that the documents that has been drawn by that advocate has the full force of law.
Okay, I'd like you to realize that this advocate is not acting as an advocate; they're acting as an estate agent. But fine, I've heard your answer. You've used the word him. Could be a lady. What is a gender neutral language? What is a gender neutral language?
I think that you will just refer to as the advocate. That is gender neutral.
What is a gender neutral language? And I don't know if you'd be happy to start with the word I think. What is a gender neutral language?
You want the definition of gender neutral?
Yes. What is a gender neutral language?
A gender neutral language is the languages that do not align to any identity based on the biological makeup of somebody, of a person. Yeah.
All right, fine, well and good. Lim, what was held in Republic versus Mwango? Real quick.
That one, I have not. I'm not averse with that, but I promise to get hold of it the moment I leave here. Yeah.
All right, let's replace it with Adan versus Republic.
Adan versus Republic.
Yeah.
The case is coming in my mind, but I can't remember the facts. I have heard of that case, Adan versus Republic, but I can't remember the issue that was in play.
All right, my last question. What is the meaning of this word, dominus litis?
Dominant?
Dominus litis.
Dominus litis. I'm not sure, but I will. Let me just an intelligent guess.
Go ahead.
I will take the word dominance to mean being dominant, and litis from the word litigation. I will then consider it as a dominant theme in matters to do with litigation.
All right. Let me give you this last one. The 3 types of searches that you know.
The 3 types of searches. We have an official search, personal search, personal search, and then historical search.
Okay, thank you, Lim. Go ahead, Angelo.
Thank you, Daniel.
All right. Lim, how are you?
Fine, thank you, Angelo.
All right. Can you please tell me what are expert opinions and are they admissible?
Expert opinions, these are evidence originating from a person that is qualified in a particular field that is in question before the court.
Okay. Can you please give me at least 3 characteristics of
sorry, there is what I had forgotten. I had forgotten the second part of your question, if you permit me, and that is whether they are admissible in court.
Yes.
The judge or the judicial officer handling that matter has the discretion to either to accept it or reject it. It's based on case by case and the circumstances that the judicial officer or the judge think applies at that particular moment to his exercise or an exercise of discretion.
Do you have an authority in support of your argument for that position?
Yeah, the Evidence Act. I can't.
When I say an authority, I mean a case law.
A case law. No, there is none that I can remember right now, at the moment.
Very
but
well.
a number of cases. What I'm sure of is that there are judgments to that effect.
All right.
But I can't remember any at the moment that can be specific to this case. Yeah.
Okay, very well. Please give me 3 characteristics of a good expert witness.
One, the person giving that, or the individual giving that evidence, has to be known to have the experience and the expertise in regards to that particular field. For example, if you are considering a case of rape, then a medical practitioner registered in a health facility will qualify to be registered, and working in a health facility will qualify to be an expert, and his medical reports or opinion will qualify to fit that. Number 2, the question of registration. I think my first point I said he has to be known to be in that field, has the experience, the necessary experience. The other thing, it should be registered. It should be registered. And then
okay, Lim, thank you. Allow me to ask you another question, please.
Correct. Go ahead.
What types of questions are asked in cross-examination?
In cross-examination, you ask leading questions. That's what the law requires. You ask leading question in a cross-examination. That means they are direct question, like, you are in this place. For example, you say you are in this particular place on this date. Is it right, correct, or wrong? Something like that.
Okay, my final question is, please give me 3 types of witnesses that you are aware of.
Wow. Okay, I will say I don't know of the categorization of witnesses, but I will say we have witnesses by the prosecution, so we can call those ones prosecution witnesses. Then we have the witnesses that the defense is relying on, then we can call those ones the defendant witnesses or defense witnesses. And then I will say probably the other witnesses that we can have are those ones that are expert witnesses. These are can I call them neutral? They are neutral, so to speak, but they just give evidence on the basis of their knowledge, and they bring in an aspect of, let's say, forensic evidence. So I would say expert witnesses, prosecution witnesses, and defense witnesses. But I don't have an authority or a scholarly basis to anchor my categorization. Thank you.
Okay, thank you, Lim. Daniel, if you may allow me, I can go first to give my feedback.
In order, sir.
Okay, thank you. I am going to go quickly, Mr. Lim, because we have taken considerable amount of time, so I will rush through very fast. You realize the questions that I have asked you may think that maybe I'm asking from maybe Evidence Act. Yes, it is true, but this is trial advocacy. Very examinable in by exams and also during oral examinations. So please, you can revisit later. So on the aspect of expert opinions, So I agreed with your definition. Okay, you see, these people, you can look at section 45 of the Evidence Act. These are people who are learned in a certain field. It can be either by experience, okay? So they are doctors, they are engineers or mechanical engineers. They give evidence in court based on their fields that they have studied in, which the same could have been obtained by way of experience. So, and yes, they are generally admissible, okay, in court. Actually, they are the most convincing evidence that can ever be produced in any court of law, okay? But now the court is at liberty, just like you said, to reject where they are not clear. And that is why I asked you whether you have an authority. And I would really like you to go and read this case, Republic versus Onyancha. Okay, it is the locus classicus case in this area on the aspect of expert witnesses. So you are going to read that one. So then again, when I talk about characteristic of an expert witness, so they are just the normal one that, confident, consistent, attention to detail, trustworthy, well-versed in their area, well-experienced, okay, effective communicator, dedicated, impartiality, okay. You have answered well on the aspect of the questions that you had on cross-examination, leading question, very well. So what you didn't answer well was the aspect of type of witnesses. You actually touched on one, the expert witnesses, okay, where mostly they provide documentary evidence, and most time they are admissible. We have hostile witnesses. I believe now, since I have started listing them, maybe they are now coming back to your mind. We have hostile witnesses. We have people called unfavorable witnesses. We have people called difficult witnesses. We also have people called refractory witnesses. And maybe it might be a question later. I'm not going to explain them, but I will ask someone to give me the difference between an hostile witness and a refractory witness or unfavorable witness. Okay, so you can look at section 161 of the Evidence Act. So that is all on my part. I would say you did well, but as a caution though, please don't explain too much. If I have asked you to give me characteristic of a good witness, just hit on point. So if I wanted you to explain them, I would say that you explain, give me 3 and explain, okay? I would go further, but it is better because you only have 10 minutes, just hit the nail on the head. It will really help you. That is my view. Thank you, Lim. Daniel, you can take over.
Thanks, Angelo. Thanks for those feedback.
All right, Lim, brutal. I know. I really tried to push you so much. And Lim, this is because we've had this session with you, and I know how far you can go. So I'd like to say that Lim, yes, it was brutal. Yes, I asked questions really fast. Of course, my response at some point was someone could say harsh, but just to push you, Lim, just to push you. And I have to say that you did well. You did well. Your answers were okay. And even the ones that you didn't know, you really tried. And man, just keep at it, man. Keep at it. You'll be fine. Keep at it. Now, estate agents and registered. Okay, the question on estate agents, you got it right. The case is Mapis Investments Kenya Limited versus Kenya Railways Corporation, 2005. And the reason as to why I used the word Mapis was just to lead you towards that particular case. I just wanted to know if you've read that case and if you know what I'm talking about. And yes, you confirm that you've read the case and you knew what I was talking about. Now, my follow-up question is where we have a problem. I talked about unregistered. I talked about an advocate acting as an estate agent. And, you took me back to National Bank of Kenya versus Anaj Warehousing. And that's not where I wanted you to take me to, because I think there's a big difference there. Now, if you look at the Estate Agents Act, and to be specific, Section 2.3, which talks about application of the Act, that Act expressly exempts advocates from the provision of the said Act. Meaning, when it comes to an advocate, we're not talking about, are they registered estate agents? No. Advocates do not need to be registered estate agents in order to practice as an estate agent. So when you're talking about an advocate, then there's an exception. Whether they are registered estate agents or not, so long as they are advocates, then they can act as estate agents. They do not need to have registered themselves first as an advocate, then secondly as an estate agent. Just to emphasize that, look at section 13 of the same act, the Estate Agents Act. Look at section 13. You'll see that it also exempts advocates from, registering as estate agents. So when I'm talking about an advocate, the advocate has to be paid. They have to be paid as per the agreement. If we said it's 4%, it's 4%. Again, I tried talking about the remuneration order just to again take you to where you should not go to. And yeah, you fell for it. But yes, so please look at the Estate Agents Act and you'll see what I'm talking about. Yeah, I hope that will be fine with you. Sorry if I pushed too much. What is a gender neutral language? You got that right. It's not pinned on gender. Of course, you can't use a word to define a word. What is gender? It is not pinned on biological orientation of a person. This includes words like they, them, their. Of course, that's a debate for another day. Now, Republic versus Mwango. I won't give you the answer, Lim. Lim, you have to, probably when we have this session the next time, I'll ask you the same question and you'll give me the answer. Adan versus Republic, again, I won't give you the answer, Lim. Please, I'm sure the way you said, you promised me very well that after this session, you're going to do your research. So I want to believe that you'll get the answer. I'm going to talk about the last question. Dominus litis, dominant, yes. You talk about dominant, then you talk about litigation. Dominus litis means the master of the suit. The plaintiff is often referred to as dominus litis. The plaintiff is the master of the suit. Dominus litis, master of the suit, master of the litigation, master of the suit, dominus litis. Lim, any questions for me?
Thank you for those comments. No question.
All right, and sorry, man. Sorry. I'm just really trying to push you because I know you can really, really do well.
It's okay. It's okay. I appreciate it. Thank you.
Okay, that's all. That's all for me.
All right. Lim, you did really well.
Yes, Angelo.
Yes, you did really well, and please keep it up. And also now to our members who are here, please let's try, because maybe we might not give answers today, but next time, for example, Republic versus Mwango, son of Mana. That is a very, very important case, especially in criminal litigation. Okay? And also Adan versus Republic. You cannot go to any exam without knowing that particular case. So please, let's put it upon ourselves, and even now you can Google and you read on it. That is all I'm saying now. Nyambura, please take it away. Thank you.
Okay, thank you, Angelo, Daniel, and Lim. Kindly let's have another volunteer. You're doing well. Let's get another volunteer. Ladies, I do not see you. Let's have a lady. Let's have someone. Anyone? Somebody? It's not that hard, guys. Let's have someone. We look at this list since you people have decided not to raise your hands. Anyone?
I think you have someone. Jeb Chirchir, Chibi.
Okay, sorry. I can't see that from my side. Just unmute. Jeb Chirchir. Can't see you. Just unmute and speak. Where are you? Any volunteer?
My apologies. I think someone removed me from the meeting, but I'm back.
Okay. All right, Abigail. So you will have two panelists asking you questions. That is Moasia and myself. So Mwasia will start, and then I'll follow. Then we'll give our feedback later. So Mwasia, then after Abigail, we have, just raise your hand. There's someone who had raised their hand. Just raise it up so that I note your name down. You'll go after Abigail. So Mwasia, just take it up with Abigail.
Thank you, Ms. Gishuhi. Good evening, Abigail.
Good evening, Mwasia.
Yes, welcome to today's session. Kindly introduce yourself in 1 minute, please.
My name is Abigail Jepchirchir Kidi from Class D, Farm 5. My registration number is 2023-036, and I'm ready to proceed.
Okay, thank you, Abigail. So I'll start by asking you a question on probate. When we say that a will is ambulatory, what do we mean?
Thank you. When you talk about ambulatory aspect of a will, it is one of the characteristics of a will to mean that a will is able to take in property that is even acquired by the testator even after making the will, so that if I make a will today and I buy land tomorrow, that will is able to factor in that land that I bought after I've made that will.
Okay, thank you. And in the distribution of the estate of a deceased polygamous man, how is such estate distributed?
Okay, thank you. Section 40 of the Law of Succession Act provides for the distribution of estate of a deceased person in a polygamous setup, and says that each family is taken as a unit, so the distribution is made according to the units, and the wives in those, the surviving spouses in those units are taken as separate units, so that they'll acquire. If we have 3 families, we'll take them as a unit each, but the wives, the surviving spouses in those units are taken as separate units.
Thank you, Abigail. What is a citation?
Okay, a citation is provided for under, I don't know the specific section, but it requires, if there's a person who is supposed to take grant of letters of administration intestate as not taken, then that person is cited to either accept or refuse to take grant, and also applies to a situation whereby there's a person who is supposed to if I think it also applies to confirmation of grant, so that if you're supposed to go and confirm, you've taken out the letters but you've not gone for confirmation, then I can cite you, and in citing that person, I'm supposed to be a person who is also of equal priority. So for example, if I'm citing a person to take up grant, it means that if they refuse to take up grant, then I can go and take grant on their behalf. And also I said applies to confirmation of grant, so that if I've taken grant and I've not confirmed, and there's a person who is feeling that they need to use the property, and I am delaying to confirm the grant, then they may cite me so that I can go and confirm the grant. Those are the 2 instances I can remember.
Thank you, Abigail. On my last question on probate, can you name for me 3 ways of revocation of a will? 3 ways in which a will can be revoked.
Okay, thank you. Section 17 of the Law Succession Act provides that a will may be revoked And Section 18 states that a will may be revoked by either there's actual destruction, there is tearing up, there is burning, and also if a testator remarries, then that marries again, then that will be revoked. And also if there is another will that is made, or a codicil that states that it revokes, that has a clause that states that it revokes the previous will, then that initial will be revoked.
Can an oral will revoke a written will?
An oral will cannot revoke a written will. A written will supersede an oral will.
Thank you. Have you come across the word SOPEC?
Yes.
What does it stand for?
Okay. SOPEC is Standards of Professional Practice. Okay, I cannot define it in full.
Ethical context. Thank you. In commercial transactions, have you tackled companies?
Yes, we did.
So kindly name for me two types of companies, just two.
Okay, two types of companies. We have public companies and we have private companies.
Okay, with respect to private companies, what do you understand by the term preemption rights?
Okay, when you talk about preemption rights, it is provided for under the Companies Act, and it states that when their shares that are being put up by the company, the shareholders have a right to first. The company should put the shares up for purchase by the companies first, before putting them up for public before putting them to the public for purchase. So the shareholders retains that right to first purchase those shares before it is given to the members of the public.
Thank you, Abigail. That's it from my end. I pass you over to the next panelist.
Thank you.
All right, Abigail. So I'll just ask you very simple questions. What are the contents of a demand letter?
Thank you. A demand letter should have first the address of the sender, the letterhead, which the sender's address, which has the name, the physical contact, the physical address, the postal address, and contact details. It also has the name, the date that the demand letter was made. It has the references. So the sender's references and the recipient's references, which at that point is normally not ascertainable. We have the recipient's address, we have the salutation, we have the which is the subject matter. The first statement of a demand letter should always give authorization, so that the person who is making the demand letter should show the source of the authority. And then now you bring in the facts and you bring in the issues that you are demanding from the other party. If there is breach, you enumerate the breach that was done by the other party, and then you make your demand, and then you give the timeline on by which the other party needs to comply with the demand, and then now you sign off. Yes, that is the contents.
Okay. When do pleadings close in civil matter?
Okay, pleadings close after service of the plaintiff serves the defendant with the summons and the plaint and the pleadings of the plaintiff serves the defendant the plaint, and then the defendant will file their response. So pleadings will close after the defendants 14 days after the defendants have been served with the pleadings of the plaintiff. So when they either enter appearance or they do not enter appearance, so it is 14 days from the time they have been served.
Okay, now let me ask you a question. Assuming you've served a notice of motion, then a replying affidavit has been put in, does it mean if 14 days lapse after you've served the replying affidavit, then pleadings have closed?
Okay. Okay. What I understand about that is, okay, my understanding is limited to filing a pleading, a plaint. But the other party can always seek leave to seek leave of court to extend time.
All right, so if pleadings close, then you can seek leave of court to file any other document.
Yes.
All right, have you heard about the case of Mukisa Biscuits versus West End Distributor?
Yes.
What comes to your mind when that case is mentioned?
That case talks about preliminary objection. And when it comes to preliminary objection, it is normally raised on a point of law, and it should be able to dispense the suits totally. And the party that is raising a preliminary objection need not to, the facts should be ascertainable. It needs not to be it does not require evidence. It is something that can be seen on the face of it, and when determined by the court, it can dispense the suit, the suit totally.
Okay, have you done insolvency and bankruptcy in commercial?
Yes, we are actually, that is the topic that we are dealing with at the moment.
Okay, so what is the difference between insolvency and bankruptcy?
Okay, when you talk about insolvency, insolvency is the inability to pay debts, and it relates to corporate entities. When you talk about bankruptcy refers to the inability to pay debts by individuals. And normally bankruptcy comes in when the court has given a bankruptcy order.
So what are the alternatives to insolvency?
The alternatives to insolvency, number one, we have a company voluntary arrangement, and number two, we have administration. Yes, that is the only ones I can remember.
So let me ask, for administration, what period of a moratorium do debtors have? I mean the company, what period do they have? When can debtors not ask for their debt? The period?
Okay,
Let's
actually,
start with defining what a moratorium is.
Okay, actually, the next topic that we are supposed to discuss is on administration.
Okay, sawa. So I'll let Mwasia give his feedback, then I'll give. Nora, kindly mute your mic.
Nora Waini.
Nora.
Kindly.
I think you're all muted.
Mwasia, kindly give your feedback
Yes.
to.
Okay. Paul, I was muted. Thank you, Jacob. Yes, Abigail, thank you for the responses that you've given. I think you are spot on with respect to the content. You got them absolutely right. I have nothing to add on that. Very well done. Out of 20, if I were to gauge you in that panel, you would have scored a 19. Good work. Congrats. Back to you, Ms. Gishuhi.
All right, I'd say the same, Abigail. You've mastered your content nicely, so that's a job very, very well done. Very well done. So keep at it, and you'll do well in your orals. I think for administration, I need not talk about it because you said you've not studied. So, but basically, a moratorium is the period that a debtor cannot ask from you in administration. So normally it's 12 months, but that period can be extended. But I think when you do the topic in class, it's going to be more clear. Otherwise, as Mwasia said, I think you've done really well. Keep at it, and I believe you'll do well in your orals. So good work.
Thank you. Thank you so much.
Yeah, let's get another volunteer who will appear before Daniel and Angelo. Another volunteer, please. Anyone? Someone? It's very easy. This is the only
Where is
chance.
Jacob? Jacob has raised his hand.
All right, Jacob. Jacob Oruko, you are ready to go?
Yes.
All right, Daniel and Angelo, take it up.
Who is the other person? If you can see me, there's someone else apart from Jacob. I think I saw 2 hands.
On my side, I can only see Jacob. Any other tutor?
We have Akumu Anyango.
Oh, we have Akumu and Sifunjo Awor. All right.
Sifunjo Awor.
Just not
All
done
right.
then. Yeah, for the
All
next
right.
session, we're able to move faster. Angelo, please start.
Okay. Thank you, Daniel. Where is Jacob? Good morning.
Good morning. Good morning too.
Okay. Can you please introduce yourself?
My name is Were Jacob Oruko. ATP. I'm taking ATP. I'm at KSL. My registration number is 2023-1087. I'm in Form 1 Class G.
All right. Very well. Let us start with probate. We have 4 minutes. Can you please tell me whether revocation of a will by marriage, if it is absolute, and if not, please give your opinion on the same.
Thank you very well, Makwe. Revocation of a will can happen through marriage, but it is not absolute. This is because the testator might have anticipated marriage while he was preparing the will. Thank you.
Okay. Are you aware of the doctrine of jus accrescendi?
Yes, I am aware, but I will beg to pass it for now.
Are you aware of, let's say, the doctrine of comorientes? Okay, no problem.
I will pass it.
Okay. Please differentiate between void and voidable marriage.
Yes, a void marriage is a marriage which is considered by the law not to have existed. Voidable marriage is a marriage which can be corrected, not really corrected, but is a marriage which may continue or may end depending on the parties in marriage. They may choose to continue or they may choose to end it. Now, this period, this is usually supposed to happen within the first 12 months.
Okay. And if I may, you can as well guide me. Who are persons capable of making a will?
Persons capable of making a will.
Yes.
Number one, the person capable of making a will is a person who has capacity to make a will. A person above the age of 18 years will make a will. However, a person below age of 18 years may make a will, but will have to execute it when he reaches, re-execute when he reaches 18 years. Otherwise, it falls. Number two is a person who is sane. Number three is a person who, can you hear me?
Yes, I can hear you. Please proceed.
Okay, number three is a person who to sane, has capacity, and another one is a person who is not bankrupt. Yes.
Okay. Can you please tell me what is corporate personality?
A corporate personality. Once a company is registered, then it becomes a person. Now, a corporate personality occurs when a company is registered, and in this case, it can represent itself, it can sue and be sued, and it can hold properties in its own name. It can execute documents using seals in its own name. It becomes different from its owners.
Okay. Can you please tell me the rule in force versus aborto?
The rule in force versus aborto is where decisions are made in the company by majority. Majority decisions will carry the day. However, if any minority, majority decisions carries the day. That's the rule in force versus aborto.
Okay. Then finally, are you aware of any development or any occurrence that might be happening in the world right now?
Any development
any
that
news, anything, yeah, anything that you think is like making headlines right now?
Yes, right now, as of today, we have probably coup in Russia. We also have war in Ukraine. Yes.
Okay. Thank you. That's all for me. Daniel?
All right. Thank you. Thank you so much, Angela. How are you, Jacob?
I'm fine. Very much, Daniel.
I hope you're well. Which team do you support?
I support Gor Mahia.
Why Gor Mahia?
It's the team from my roots.
Okay. All right. That's fine. What about the English Premier League?
English Premier League, I support. Right now, I go with Chelsea.
Okay. All right. That's fine. Meaning you keep changing from one team to another.
Yes.
All right. Whether that is loyal or not, I don't know. Anyway, just a few questions for you today, Jacob, and I hope you'll allow me. So just the other day, I was going through YouTube and I saw this very, very intriguing debate. And it's between Jordan Peterson and some students at a university in Canada. And these students are transgender. And what they're trying to tell Jordan Peterson is they have the right to be called they and them and to use those particular those particular words when referring to them, and you cannot refer to them as him or her, and the way we usually refer to girls and boys in our country. And according to him, his argument was you can't use they and them and all these other languages because they refer to plural. They don't refer to a singular person. What is your take in relation to that idea? What do you think? What do you think?
In reference to them being referred to as they and them.
Yes, and not him and her. Yet they're boys and girls.
I think everybody has a right to require to be referred to as they would wish to be referred to based on their past or based on a reason which best sits with them. However, this should also be protected by the law, and in order to avoid some confusions, then in this case we can protect their rights, but it also it can be protected well if it was provided for legally. Otherwise, it might bring confusion.
So there would be no confusion if there was a legal provision protecting the right to be referred to as they.
Yes, there will be no confusion because the process of passing a law with respect to such kind of references is a process which involves public participation, and it's a process which even involves them and creates a better understanding and also protects them better. But in this case, referring to them as they and them sometimes might also cause confusion.
So either way, it will still cause confusion.
I don't think it will cause confusion if it was legally provided for.
So if it is legally provided for, then referring to them as they and them wouldn't cause confusion.
It wouldn't cause confusion because whenever a legal provision is made, then these legal provisions will also protect them. And in this case now, even the forms that we are filling and all those requirements will be adjusted to take into account the fact that we have transgender, the fact that we have all of these people who want to be called as them and they.
All right, Jacob. So I'll take you to conveyancing. Yeah. I'm currently involved in this transaction where person X is planning to transfer their property worth 50 million to person Y, but I'm representing person Y, the purchaser. So the purchaser, person Y, informs me that person X wants to transfer this property as fast as possible. In fact, they would appreciate if you were able to transfer this property by the end of next week. In your own opinion, or in your opinion, do you think this is possible? And apart from that, what would you be looking for before you go forward with this particular transaction, taking into account the fact that it is really, really rushed?
When it is really, really rushed, it may not be possible because we have to first start by searching to know the owner of the property, and such certificate which will usually come out between 5 and 10 days. After the search, we also have to check whether this property is freehold or is leasehold, and if it is leasehold, then we must also obtain the respective consents for us to transfer the property. And also we have, yes.
Okay, go ahead. But just try to answer my question. I asked, is it possible?
Yes, it is possible.
Okay. What are some of the things that you'd be looking for before you continue this transaction?
First thing I will be looking for is who is the owner of the property.
So basically you'd conduct a search, yes?
Yes, I will conduct a search.
Give me 3 reasons why you'd have to conduct a search.
Now, a search number one reason for conducting a search is to ascertain the real owner of the property or the person in whose name the property has been registered into. Number two, the search will also help us to ascertain whether the property is under leasehold, and if under leasehold, how many years are remaining, and also if the property is freehold. And then number three, search will also help us to limit litigations in the future. And it also helps us to save time because we will be dealing with the owner of the property.
Okay, that's fine. I'll ask you my last question. You've talked about freehold and leasehold. What is the difference between the two?
Leasehold, number one, leasehold, first of all, is a property which, first of all, the lease stays with the government. So leasehold is a property that is given to someone for a period of time, 99 and below in Kenya. So in leasehold, you can transfer to another party, to the purchaser, certificate of lease. When it comes to freehold, then this property does not have a respective term or a period within which the purchaser will hold it for. And in this case, we will transfer certificate of title to this person.
So the only difference is that you transfer certificate of title and certificate of lease?
Once the period expires in lease, the property reverts back to the owner. And then also in lease, you will be paying rent. When you're using the property, in lease, you'll be paying rent. Yes.
Which right do you have when you have a leasehold, and which right do you have when you have a freehold?
When you have a freehold, you have
the right you have in relation to the property. Basically, does Article 40 apply to someone who has a freehold, who has a leasehold? Article 40 of the Constitution, that is.
Article 40 of the Constitution.
Yeah.
Yes, Article 40 of the Constitution applies to someone who has a freehold.
Now, in what sense?
In Article 40 of the Constitution, first of all, provides that anyone can hold property in any form in any part of the country. Leasehold forms part of property which can be held in any part of the country. So in which case, once the property has been, once the leasehold, I don't know if to call them the leasehold rights, has been transferred to me, then that becomes my property for the period that we have agreed, be it above 21 or above 2, but during that period, Article 40 protects my rights in that property.
All right, what's a leasehold right? That's what I'm looking for.
Leasehold right?
Yes, what's a leasehold right?
Now, this is the right to hold property for a given period of time, usually granted by a lessor to a lessee after payment or after an agreement, and the lessee is usually supposed to pay some rent.
All right. What's the difference between a leasehold and a license?
A license does not guarantee, first of all, a license is given by the owner of the property, and it allows you to only utilize the property. You cannot transfer a license to another party or to another person. So it only allows the licensee to utilize the property, access and utilize the property for the period agreed. Once it expires, then maybe the nanny has the right to give another one, the licensor, and a leasehold transfers, if it's above the 21 years, it transfers the title to the lessee, and in which case, once the title has been transferred, then we can have the issues of sublease, where I can sublease the property to another party. But license, you cannot transfer license to another party. Once you're given, it's only you who's supposed to utilize the property. And it is limited. Yes.
All right. Thank you so much, Jacob.
Thank you.
My comments, Jacob, you've brushed up, and that is really, really good. You've continued to sharpen the iron, and I think that is very, very clear here. From the first time we met and now, I think the difference is quite huge. And Jacob, you're on the right trajectory, man. I wish you all the best. I like your confidence. I like the clarity in your answers and the fact that your answers were short and clear. Yes, whether wrong or right, you ensured that they were short and you didn't go through all these corners that maybe sometimes someone would tend to go through to ensure that, at least we know that they know something. Now, when I asked you about a leasehold and a freehold, when you have a leasehold, you have the right to exclusive possession. Jacob, maybe you can just note that down. In a leasehold, you have the right to exclusive possession. So the only thing you have is exclusive possession. In a freehold, you have the right to use, possess, deal with the property in any way whatsoever. So someone who has a freehold has a better right than in a leasehold. In a leasehold, the only thing you have is exclusive possession. If you want to deal with the property, for example, if you want to sublet, you have to get the consent of the owner. The owner is the person who has a freehold right. So that's why I asked you that particular question. Now, the difference between a license and a lease, yes, that was okay. Now, I'm not saying this, Jacob, to mean that the differences you gave between a leasehold and freehold were wrong. They were correct. Just that when I asked you the particular right, you are not very clear on whatever it is. You said a leasehold right, and I kept on asking, what is a leasehold right? So the leasehold right is the right to exclusive possession. The freehold right is the right to use, possess, and deal with the property in any way whatsoever as you'd wish, according to Article 40 of the Constitution. And of course, leasehold also falls at Article 40 of the Constitution. Just that the only right that you have there is the right to exclusive possession, nothing else. Okay? Now, I also asked about the debate. Now, when you asked such questions, Jacob, I think you did very well. You used your mind, you applied your mind, you said what you think. You didn't care about what I think or what I'd say. You just told me what you think and how it is, Jacob. And I want to believe that you did well. Sometimes when you ask such open questions, we just want to know if you're able to come up with an argument and stick to it. And I think you did that. What else did I ask you about? Why we conduct searches, your answers were proper and correct. Now, if I were you, after giving the answers, and maybe just state the types of searches that I know, just to show the lecturer that I actually know what I'm talking about. Jacob, is there any other question that I asked you that maybe I have not talked about?
There was the issue of Comorientes. I was asked. Oh, it was not you. It was Nani Makwe who asked that one.
Yes, that was Angelo. So I want to believe that I've answered all the questions that I asked you, Jacob. Man, keep going, Jacob. You're on the right trajectory, man. Yes. I pray that you get your 19. Angelo?
All right. Thank you, Jacob, for answering my questions diligently. I will just only comment on one issue, and I would like to refer you to Section 43 of the Law of Succession Act. And maybe on the aspect of the procedure, you will get it in the land registration, or is it general regulations, or there you will go and do your own assignment. So actually, this was a question that I was asked during my orals. My panelists just say, are you aware of the doctrine of jus accrescendi? I was lucky, I was aware. Okay. So it is that aspect of joint tenancy, how the right pass from maybe a tenant, people own property together through what is known as joint tenancy. Then one dies, and then the property will pass to the living person through survivorship. So now that survivorship, or that thing that I have just explained, so that one is called jus accrescendi. Okay, it is on the aspect of survivorship, or how the property passed from one joint tenant to a surviving joint tenant. Okay, and having said that, now you can distinguish it to the aspect whereby, what if now these two people die together, but you are unable to determine who among these two joint tenants died first, because you see the one who let's say the surviving one is supposed to be the one who takes the property. Okay, so what if now let's say they die in a road accident, okay, a fatal road accident or RTA. So now then it is going to be said the older joint tenant will be said to have died first. Okay, and that is where the doctrine of comorientis now comes in. Okay, these two people own a property together. For one reason or the other, they attended this WRC in Naivasha. Unfortunately, they pass away. Okay, while let's say they were involved in an accident. So now the person who is older among these two persons will be said that he died first, and then now the surviving one, the younger one will take the property. So that one will go to his or her estate. So that is all on my part. Thank you. Unless if you want me to answer any other question.
No, I am fine. And thank you very much.
All right. All right. Thank you. You did well. Thank you, Nyambura.
All right. Thank you, Daniel and Angelo. Akumu, are you with us? You had raised your hand earlier. Akumu?
Yes, I am.
All right. You're ready to go?
Yes, I am.
So you'll have Mwasia and myself. So Mwasia, you'll go first.
Hello, Mr. Akumu. Good evening.
Good evening.
I'll skip the introductory bits. I know by now every student in the forum appreciates the manner in which the introduction is to be made. So I'll go straight to the questions, Mr. Akumu, if you so allow. So let me start with this. Are you aware of the Advocates Act?
Yes, I am.
The Advocate Act can say dictates the conduct of the advocates and gives various agreements that it terms as invalid agreements with respect to advocate-client conduct. Can you name for me 3 invalid agreements recognized under the Advocates Act?
Okay, so as a preliminary, basically invalid agreements are the ones that advocates are precluded from engaging in by the Advocates Act. So an example of I don't really recall the names, but I'll try and describe them the way I understood them. So we have what is commonly referred to as contingency agreements. So this is where when an advocate enters into an advocate-client relationship with a client, they tend to peg their payment on maybe, let's say, they agree to conduct the matter without any retainer or without any payment made to them. But at the end of the agreement, at the end of the litigation process, they can say that upon me winning, then I'll have maybe a share in your land, maybe, so in the client's land. So they place a contingency of the fact that they are going to win on a particular aspect. It can be a land, it can be a house, or any other benefit. So that kind of agreement is precluded by the Advocates Act. And we also have the ones maybe an advocate can I'll refer to them as an exclusion of liability agreement, where an advocate says that upon the case losing, then it more of appears like at your own risk. When I lose the case, then you are not supposed to put the blame on me or something like that. So they are basically trying to exclude risk at the expense of them losing the case. So those are the two agreements that are limited, that are limited by the Advocates Act that I can recall. Yes.
Thank you, Mr. Onyango. Now, can you name for me 5 types of penal sanctions recognized in Kenya under the Penal Code?
So the types of penal sanctions that I can recall of, we have sentencing. So sentencing is where maybe when a person has been convicted, so during sentencing, maybe there can be the type of sanction that stems from there can be maybe life imprisonment. We have imprisonment, and we also have where an accused person can be sent to probation. Yeah, so we have probation, a type of sanction on probation, and also another type of sanction. Maybe I can limit it to juveniles, where you find when a juvenile has been convicted of a crime, then they can be sent to a juvenile house, for lack of a better term. So they can be taken through the process of rehabilitation and the process of trying to bring them back to the order that is being maintained by law in society. So I can also talk of, those are the ones that I can recall of at the moment. Yes.
Okay, thank you, Mr. Onyango. Kindly name for me the objectives of sentencing that you can remember.
So the objectives
or
of
just give me 3, please. Just
okay,
3.
So objectives of sentencing, we can have one. It is meant to rehabilitate the offender, so that when we have rehabilitation. And another objective of sentencing, we can talk of to prevent recidivism. We have the aspect of trying to reduce recidivism in the society, and we also have retributive.
Good. Now, yes, Mr. Onyango. I think that's fair enough. Thank you. Now, kindly advise me or help me understand. Assuming I'm starting my own legal practice in an outskirts town, what considerations will I make when I'm making the decision on the location of my office?
Okay. So there are quite a number of considerations that a person who wants to start their own practice needs to take into account. So maybe they are provided, maybe we learn them under legal practice management. So they are one consideration that you'll take into account can be maybe your clientele. What type of client do you want to target by you deciding to go into that particular location? So such that while setting up your practice there, then you ought to know that the client you intend to attract, you will be able to find them there, and that will be premised on the type of practice you want to specialize in. Let's say, for example, in Kenya you want to specialize in sports law, then a proper place will be Eldoret, because we have athletes and sportsmen who have a reputable recognition in Kenya reside. So you can decide to go. So the first consideration is clientele. Another consideration can be maybe accessibility to the court, because when you're setting up outside Nairobi, then I tend to assume, I'm inclined to believe that there can be the only way that accessibility to the court might be a challenge. So you'll also tend to look at your how close you'll be to the court. Is it accessible from where you're setting up the practice? And then another consideration will be accessibility to the most important amenities. Are you close to maybe a bank? Are you close to so that when your clients intend to access mobile services, then they can money services, then they can be able to reach there quite easily. So those are the three considerations that I'll advise you on.
Thank you. On current affairs, who is the current Attorney General of Kenya?
So the current Attorney General of Kenya is Justin Muturi. Justin Muturi.
Justin Muturi. And
yes.
Have you heard about the Dina Properties case, Dina Management versus the government of Mombasa case?
Yes, I have.
What was it about?
So
just briefly.
Okay, briefly. Then it was about the acquisition of public land, because actually recently the Supreme Court rendered a ruling on the case. So it was about acquisition of public land. So Dina had acquired land that was the first person who had actually illegally converted it from a public land for private use was the late President Moi. So the Supreme Court, in ruling on the case, actually opined that the fact that public land changed hands from different acquirers does not necessarily mean that the latest owner of the latest acquirer of the land then will be precluded from the fact that it is a public land. Public land remains to be public land, and as a purchaser, you ought to exercise the reasonable amount of due diligence. And since there was an aspect of historical searches in this case, then you are actually advised as an advocate to consider the Ndungu report when conducting historical searches, then so that you can be able to know that is your land mentioned in the Ndungu report. So it was about public acquisition of land. Yes.
Very well put. My last question before I hand you over to Ms. Gishui. Kindly name for me 4 rules that govern the conduct of advocates,
so
or the practice of advocates.
So the 4 rules that govern the practice of advocates then will be confidentiality. Then
No. I want the rules under subsidiary legislations, like we can say the advocate remuneration orders that guide us on the remuneration of advocates.
Okay.
Yes, can you proceed?
So we have the rules that govern advocates. We have the Advocates Act. We have the LSK, the Law Society of Kenya Code of Digest and Etiquette, and we also have the Advocates Account Rules. We have the Advocates Practice Rules, and you can also mention the Advocates Marketing Rules. Yes.
Very well put. Very well put. Yes, I think that's from me. That's it from me. Ms. Gishuhi, kindly proceed.
All right. Thank you, Mwasia. Hi, Onyango.
Hello.
I just have a few questions for you. So, have you heard the case of Popat versus Popat?
Popat versus Popat. I am afraid I haven't come across it, but if I'm given a reasonable amount of time, then I'll research on the same and give an answer. But at the moment, I haven't.
Okay, sawa. So now, assuming a will was left and one of the beneficiaries feels like they haven't been sufficiently provided for, how are they to approach a court to get reasonable provision?
So they'll approach a court by way of So before I give my answer on how they'll approach a court, then I'll beg to establish a distinction between, let's say, maybe if it is under tested succession, then the person aggrieved will approach the court through section 26 that provides for reasonable provisions. Then if it is intestate succession, then it depends now on, so if it is intestate succession, then a person who's aggrieved, then it will depend on the stage of the case that they tend to come in. So let's say it is during the stage of maybe confirmation of grant, then they can okay, so then they can actually, if it is the stage of confirmation of grant, then they can actually object to the confirmation of a grant. And if, let's say, the grant has already been provided for, then they can approach using where they intend to revoke the will, and then basically all these applications are made by way of a petition. So but the difference lies between whether it is tested succession or intestate succession.
Okay, now let's talk about transfer of, assuming you executed a sale agreement some 5 years back, but that sale agreement has not been registered. What is the position of the property? Who has ownership of that property?
So if you've entered into a sale agreement of land and it has not been registered, then the ownership would actually reside on the vendor, the person who intended to transfer the property to the purchaser. So ownership will reside on the vendor.
So if the vendor now refuses to register it in the name of the purchaser, what recourse does the purchaser have against the vendor?
So maybe the purchaser can, once that happens, then they can actually issue a completion notice so that the vendor can actually perform their end of the bargain. So they can issue a completion notice to the vendor. So the vendor, if the vendor now fails to honor the completion notice, then the land will, I can't give a position, but they can issue a completion notice to the vendor so that the vendor can perform their end of the bargain. Yes.
Okay, sawa sawa. So what modes of terminating proceedings do you know?
So the modes of termination of proceedings, you can talk of maybe when the proceeding when the case has been heard and determined, then the suit terminates. So the proceeding will terminate if it has been heard and determined. And it can also be terminated where maybe where there is no, let's say the property subject to the suit, or there is no cause of, the property subject to the suit is non-existent, then the suit can be terminated. So the plaintiff can either terminate so let me take a break then and try and give an answer. So a suit can be terminated, maybe I beg to pass. I don't have a clear answer at the moment.
Okay, in relation to that question, do you know what striking out proceedings mean? Or does that give you any lead?
Okay, yeah. Striking out pleadings, it gives me a lead. It gives me a lead.
Uh-huh.
So let's say striking out pleadings is basically where maybe the pleadings that have been served are defective. So in such a case, then the court can strike out the suit, so that the court can strike out the suit at the moment.
So would we then say that that's also a mode of terminating proceedings?
If you have defective pleadings that have been served, then it will be a way of terminating a proceeding. Yes.
Okay. So what's the difference between a decree and an order?
A decree and an order. So a decree is basically that which is used to execute a judgment. So if a judgment has been made, then for the judgment to be executed, then a decree has to be issued in regards to the same. But then an order is maybe given after an application has been heard and determined. So let's say in the course of the proceeding, the plaintiff may be seeking an injunction. So once the court hears and determines the matter concerning the injunction being sought, then it will give an order. So an order is given when an application is made, but a decree is given for the purposes of executing a judgment. Yes.
So just a follow-up question. Now, assuming a court was hearing an application, so the determination they give is called an order.
Yes.
Or what determination does a court give when they hear an application to conclusion?
So maybe they'll give an order in regards to the same. So maybe if you're seeking an Anton Pillar, then it will be given in the form of an Anton Pillar order. So it will be an order.
All right, I'll just ask you the last question. What's the difference between judgment and sentence?
So judgment, basically, I'd say that judgment is the final determination of a court. So let's say, I'll give an example of, but it's the final determination of a court, but a sentence is given to execute, to confer a sanction against a person who has been convicted. So sentencing will be in the form of imprisonment. It will be in the form of, giving a sanction after a person has been convicted.
Okay, sawa. Let me just give my feedback before Mr. Mwasia gives his. So you did pretty well. That shows you've read. So when you talk about the case of Popat versus Popat, I asked you specifically, the question that followed was on reasonable provision. So basically, Popat versus Popat was a case in Mombasa where the father had left a will. It's basically about reasonable provision. So if someone mentions Popat versus Popat to you, then just know it's a reasonable provision. Yes, the gentleman had been left some millions, but the father was extremely rich, and the court held that in as much as he had been given millions, that was not reasonable provision compared to the wealth that the father had. So look at the case, you'll get more guidance. The other question on effect of transfer, that was good, you did well. Modes of terminating, you can have when a plaint has been heard to conclusion, striking out of proceedings. A court can give a summary judgment, and that will terminate the proceedings. So when you talk about a decree and an order, decree, you did well, it is extracted from a judgment. However, for an order, when a court hears an application, what they give is a ruling. So these orders are normally extracted from the rulings. So a court doesn't give an order after hearing an application, they give rulings. So it is from those rulings that orders are extracted. On judgment and sentence, you did pretty well. So keep at it and you'll do well in your orals. So I'll let Mr. Mwasia give his feedback.
Well, Mr. Onyango, you handled the questions very well. I like or I appreciate your confidence, but be precise in the explanation so that you don't waver out of the question asked, because that will open floodgates of follow-up questions, especially if you meet an inquisitive panel. Now, on the invalid agreements, those are contained under Section 46 of the Advocates Act. You handled them well. They include the agreements in which the advocate is entering into an agreement for payments of fees below those stipulated by the advocate remuneration orders, or agreement relieving of the advocate liability, agreements in which payment is contingent on a win or dependent on a win, or even agreements in which the advocate purchases an interest in that case. Now, on the penal sanctions that are recognized in Kenya, again, you did well. We've got the death penalty, we've got community service orders, probation orders, can have fines, forfeitures, compensation, and so on. Then on the objectives of sentencing, I don't know if you've covered that yet, but still you managed to tackle the question well, where we can say the objectives will be like retribution, rehabilitation, restoration, deterrence, community protections, and denunciation. So you answered the questions well. Then on the order, on the rules that guide the advocate's practice, again, I had asked 3, you got 2 right. We have the advocate remuneration orders, advocates practice rules, you had that. We've got the advocates deposit rules. There are so you can find them under the subsidiary legislation. Then have them in your fingertips. You never know the questions that the panelists may pose. Then on the questions of the location of an office, may sound so simple, yet on the pressure of things before a panel, you may find those pointers going away from yourself. So well done. That was a nice attempt, Mr. Onyango.
Thank you so much.
Karibu.
Thank you, Onyango. Thank you, Mwasia. Sifunjo Awor. Are you with us? Sifunjo Awor?
Yes, I'm here.
You're ready to go?
Yes, I'm ready.
All right. You'll appear before Daniel and Angelo. Angelo, you can start, then Daniel will go after you. Angelo, are you with us?
Oh, yes, I'm with you.
All right, take it up.
Her name is Awor.
Yes, Sifunjo Awor.
Okay. Miss Awor, good evening.
Good evening.
Yes, my questions will be straightforward because we are now at 23 hours. So please state 5 rules of a good drafting.
The rules to a good drafting include: 1, should be precise and concise to the issues. 2, in some instances, a good drafting should plead specifically, for instance, fraud, when pleading fraud. 3, it should take into consideration the audience. 4, it should be drafted in plain English and avoiding legalese and jargons. And the last characteristic would be that it should be drafted. It should be drafted with the aim of meeting the needs of your particular audience.
Okay, very good. Maybe if you can proceed further, please define for me 1, legalese, 2, plain English, then proceed to give me at least 2 differences between legalese or plain English.
Thank you for that question. I'd say legalese is an archaic language that is used in the legal profession and that is familiar with the legal professionals and may not necessarily appeal to the layman. Then plain English is the opposite of legalese, whereby the language used is simple, clear, and can be easily understood by a layman. So an example of a legalese would be, for example, hearing. So in a sentence, you'd say, as described herein, and then proceed with your sentence. But then if you'd phrase that in plain English, you'd say something along the lines of, as described below, or as described in text, then proceed to state your sentence.
Okay. And if I am to proceed further, please state the name of the case that overturned the famous case, or the or is it more celebrated case of Roe versus Wade in the United States?
So the principle of the right to abortion, I believe, was overturned in the case of Planned Parenthood v. Casey in the United States.
Are you sure?
I am not sure.
Okay. Sawa. My second last question. Let's say, for example, when you are being admitted to the Kenya School of Law, there were few of your colleagues who were rejected. So please tell me, if you are aggrieved by the decision of the KSL to admit you, which court do you go to? Or is there any institution that you go to? Or what is the proper forum?
Thank you for that question. I'd say with regard to that particular question, I'd term the decision by KSL as a decision made by the organization or the organ. It is an administrative decision, and therefore, if there is a provided channel for recourse within the organization, then I think that would be the your first stop. But then, if you still feel aggrieved over that particular decision, you can appeal to the High Court and go under judicial review, and you'd probably be seeking the court to grant you certain orders. For example, maybe you'd pray for a mandamus in order to sort of compel the organization into perhaps accepting you into the school. So I'd say yes, you can appeal to the High Court, and you'd go under judicial review. Should be I think rule 53 of the Civil Procedure Rules.
Again, are you sure about that? Did you say Rule 53? Or maybe I have not heard you right.
Yes, I said Rule 53.
Okay. Can you please differentiate for me between recruitment and selection?
recruitment and selection, first of all, they are both human resource management practices. The difference is that with regard to recruitment, it speaks into the process of advertising the job or the position in order to get viable candidates. So you recruit them, and then selection is a more inclusive process. So while selection is a more exclusive process. So while recruitment is an inclusive process whereby you're selecting the viable candidates and those who have passed the particular requirements of the job description, selection is now where you conduct the interviews and come to a conclusion and settle on one particular candidate or the prescribed number of candidates for that particular role. So, while recruitment is an inclusive process, selection is an exclusive process.
Okay, under 30 seconds. So what is a separation policy?
I'm afraid I'm not conversant with that.
All right. Thank you. Daniel?
Thank you, Angelo. Can you hear me?
Yes, clear.
Okay, how are you doing?
Very fine, thank you.
All right. Who is your conveyancing lecturer?
Mr. Antonio Pulo.
Okay. All right, I'll ask you a few questions. My good friend Angelo, Joshua Ougo, kindly mute. My good friend Angelo wants to start a shop in Kenya, Nairobi to be specific, that sells products for Louis Vuitton. And he has come to your chambers to ask you on the procedure and what he needs to do, what he must do to be able to have this shop in Kenya. Kindly advise.
Okay, so in my understanding, if he wants to open a shop, then within the definition of the Rent and Business Tribunals Act, he would be required to enter into a lease agreement with the landlord of that particular shop where he seeks to carry out his business. And thereafter, in entering the lease agreement, then he would be under controlled tenancy, and he would thereafter have exclusive possession of that particular shop, and he'd be able to carry out his business for the duration of the lease period.
That's correct, but of his main concern is about having a shop in Kenya, selling clothes or products for Louis Vuitton, and having that shop called, a Louis Vuitton shop, using those specific names. Would that be proper, or is there anything that maybe he'd require that would allow him to actually operate such a shop in Kenya?
Okay, so in that situation then, I'd prescribe that the Louis Vuitton name, I believe, is a trademark, and there is a particular renowned business that operates with that particular name, and therefore it might be risky to get into business with that particular name, as he may be accused of violating the trademark IP rights. However, I believe if he can get a license to use that name in Kenya, in our jurisdiction, then I think he can, if he can get a license from the owners of the name or the trademark, then I think he can proceed to operate using that name. And of course, with that in mind, he would be required to, in obtaining that license, he'd be required to, of course, pay certain royalties to the original, should I say, owner of the trademark.
All right. Is that specific name given to the agreement between Angelo and Louis Vuitton?
Sorry?
what's the name of the agreement that will be entered into by Angelo and Louis Vuitton? Different types of agreements under commercial transactions. One of them would apply here. Which one?
Okay, so I believe that would be a franchise agreement.
Why?
Because he wants to, if I'd put it in a simpler term, he'd want to sort of adopt the general practices of that particular business in its original jurisdiction and bring it into this jurisdiction, and therefore that being a chain, he therefore need to sort of adopt the business as it is with the parent company. And so in entering into a franchise agreement, the parent company will be able to give him the rights to operate in as far as he operates within the confines of the regular business as carried out in the original Louis Vuitton company.
Okay. So my good friend Nyambura really likes, Louis Vuitton products. In fact, that's the only thing she wears. So she decides to buy a sweater from this shop established by Angelo. And after a few years, she realizes that the sweater is fake. It's actually not the real Louis Vuitton. In fact, some of the sweaters like the one she has are being sold at Gikomba. And she saw one of her friends with that particular sweater. That's why she knew that sweater, was actually fake. If Nyambura comes to your office, who do you think would be the right person to sue? Angelo or Louis Vuitton, the global Louis Vuitton?
I believe it would be the global Louis Vuitton. And this is my reasoning. With regard to the copying of the design of that particular, for example, the logos, the Louis Vuitton logos, I believe it should be a copyright infringement. So when it comes to copyright infringements, I believe that the owner of the copyright is the proper person to sue or has locus standi with regard to infringement of their particular right. So I think Louis Vuitton should be the proper person to sue.
Okay, so I'll just add a few facts to this particular case. So Angelo has also come to your chambers and confessed that, truth be told, he decided to go and buy this sweater from Gikomba. And, just to make money, he decided to put it in the same store and sell it to Nyambura. Would that change anything?
Yes, I think it would.
You think, or you're sure?
Okay, it would. And this is my reasoning. When now the facts change such that he does admit that he went to buy the fake Louis Vuitton and brought it into his shop, then the affected consumer who bought it with the belief that it was the actual design would now have locus standing, because then in that particular scenario, it could arguably be a breach of a contract. It could be a misrepresentation, because when there's a sale going on, then there's definitely a contract between the buyer and the seller. And so if you find that particular sale was done in terms that were misrepresented, that this sweater is the actual Louis Vuitton, yet you come and find out that it was the fake Louis Vuitton, then I think you can have recourse as the affected consumer, and that is under the Constitution as well as the Consumer Protection Act. You can resign that contract and you can also sue.
So who will you sue? You'll sue Angelo or Louis Vuitton?
Angelo.
Okay. Why would you sue Angelo in this particular circumstance? What's the difference?
in this circumstance, I believe the parties privy to the contract should be Angelo and the buyer. And so the person to be directly sued would be Angelo in this case.
But Angelo is selling under the name Louis Vuitton, not under his personal name. And the company and those who operate it as separate entities as held in Salomon versus Salomon. Would you still want to maintain your advice?
Maybe if I can go back to your facts, you're saying that Angelo is selling this product under the company name, and therefore, because of the SLP, he would not be liable. I think the separate legal personality, the corporate veil could be lifted, where there can be fraud, that there can be proof of fraud. And so if Angelo was operating under the name, ideally you would sue the company, but if you can prove that there is fraud involved or mischief on his part, then that veil could be lifted. I do not think that principle is absolute.
Thank you. That's all from me. Angela, you can give your views.
Okay, I don't have much. Or what I would say is for a war to consider my question on the aspect of maybe you don't agree with the decision of KSL. Will you go to the Legal Education Appeals Tribunal, or do you go to the High Court Direct Judicial Review Division in the circumstances? So that is your assignment. Do you go to the Legal Education Appeals Tribunal? So maybe you need to get what is the jurisdiction of that particular tribunal, or do you go to the High Court Direct? Okay. Then I will also give you the task on recruitment and selection, and also separation policy. So the time is not on our side, so I will just give you that assignment so that you can look them up. So that is all I can say on my part, unless if you have a question that you want me to answer, or because I think you did really well. You answered all my questions.
Thank you. No.
Okay, thank you.
Our, I think you did well. In my opinion, you did very, very well. Great stamina, great agility, great confidence. You are clear. You know, I know at one point you said you think, but when I asked you, you think, I mean, you retracted that comment and said what the answer is. And I think that's really, really good. I'd like to wish you all the best. Now, IP issues are quite interesting. And I think even by me asking you such questions, you see how much and why it's very important for us to just, delve into IP and see what these things mean. Because I mean, that's the world that we are going into in the future. I mean, they say Africa to the world. So these things are coming up and we need to know what to do. Yes. Now, in relation to liability, I'm going to look for the case and probably post it in the group during the week. But according to a case, a decided case, again, this is something that you can always say in oral, so you don't know the exact name of the case. In a decided case, it was held that when it comes to liability, it must be proven that in the event that you decide to sue, or in the event that you're saying that the owner of the franchise, the original owner, in the event that you're saying that Louis Vuitton are the ones who are responsible, you must be able to prove that they had control. You must be able to prove that they had control. So if they had no control, then they wouldn't be liable. The person who would be liable would be Angelo. And yes, the veil would be lifted where we have fraud. And this is an instance of misrepresentation and fraud. I mean, he decided to buy these clothes from somewhere else and sell it in a shop that belongs to Louis Vuitton. So when it comes to liability and, in matters trademark and IP and all this stuff, one thing that has to be proved is whether there was control from the main owner of this trademark. If there was control, then they would be liable. But if they had no control whatsoever, then you would have an issue. I'll look for the name of the case and share it with you. But all the same, Awar, I think you really tried your best to answer the questions. I think your argument made so much sense and you stood with them and you were able to think outside the box while giving me the answer. Despite the fact that I was pushing you to different directions, you ensured that you stood your ground and, gave me answers that made sense. And, we even talked about, lifting the veil and everything that, are perfect and they make perfect sense, man. I wish you all the best and, may you get that 90. That's all from me, Nyambura. Unless you have a question for me, Awar.
No, thank you. Thank you.
Okay, all the best. Nyambura?
All right, thank you, Awar. Thank you, Daniel, and thank you, Angelo. Let's have one last volunteer, then we will take your questions. One last volunteer. Kindly, anyone, raise your hand. I can't see. So, anyone? Please, anyone just raise your hand. Let's have one last person to appear before Mwasi and Angelo. Gertrude Kanyaha, do you want to try? Gertrude? Anyone? Any volunteer? You people will get very simple questions. Let's get one last volunteer so that we close today's session. Amadi Sylvia, do you want to try? Amadi Sylvia?
Maybe it is time to choose our lucky winner.
Please go ahead, Angela. Get us someone.
Okay. All right. Let's finish this. Odur Donna, you can unmute, please. You are our lucky winner of the day.
Good evening.
Yes, good evening. Yes, how are you, Donna?
I am fine, and you?
Oh, but you are the one you have unfortunately or fortunately won our is it called Lotto? Yeah, something like that. Okay. Now I have two questions for you. If not three, but two. I will go with two. Can you please state for me any three immunities that you know of?
Thank you for the question, Angelo. So this diplomatic immunity, this one shields the members of the, it shields diplomats basically from suits and yes. And then there's the presidential immunity whereby the president cannot be sued in court for a criminal or civil matter, I think, in the country. And then there's the immunity that is granted to judicial